Swayam Prabha. Digital India. Educated India.
Hello viewers, I am Dr. Saurabh Rana from Faculty of Law, University of Delhi. I, along with Professor Dr. Vageshwari Deshwal, Faculty of Law, University of Delhi, would be discussing procedural criminal law contained in Bharatiya Nagrik Suraksha Sanhita 2023, and today our topic would be the miscellaneous provisions in Bharatiya Nagrik Suraksha Sanhita 2023. In this session, we shall discuss chapter 25, which is about evidence in inquiries and trials, and chapter 27, which is about provisions as to accused persons of unsound mind. Here, we are not contemplating a situation where the accused was unsound mind at the time of commission of crime, but we are contemplating a situation where he is of unsound mind at the time of trial and thereby incapable to look after his interest as in to raise his defense. Now, let us start chapter 25. It says, language of court. Section 307 says that the state government may determine what shall be for the purpose of this Sanhita the language of each court within the state other than the High Court. So, it would be the state government which may decide the language of each court within a state other than the High Court. Now, if we look at Article 348 of the Constitution, it says that the language of the High Court shall be English. However, the governor may, with the consent of the president, previous sanction of the president, may declare, may authorize the use of Hindi or any other language that is there for the official language of the state, that they shall be used in the proceedings in the High Court. But then such declaration, such notification shall not work in respect of the judgment, decree or order passed by such High Court. So, their language shall remain in English. The reason would be that they may be taken to the Supreme Court in appeal, etc. So, that would be the reason. Now, it says, as we have seen, state government may determine the language of each court within the state other than the High Court. Now, you see, as in Govind Ganesh versus R.R. Mirokhe, 2010 Bombay High Court observed that by a notification, state government in Maharashtra declared Marathi as the language of court, then in that case, the record of the court in state of Maharashtra shall be prepared in Marathi language. Though the High Court further observed that if High Court by rule provides for that, then simultaneously a copy, especially in those cases which may go to High Court in appeal, etc., appeal revision, etc., that simultaneously a copy of the record shall be prepared in English also. So, language of court means that the record shall be prepared in that language. As I said in this case, that the record shall be prepared in Marathi in Maharashtra court as the state government provided. It does not mean that the witnesses cannot speak in any other language in the court. So, the witnesses or when the accused suppose is examined in the court, it does not mean that they would not speak in the court in any other language. So, if they speak in any other language except that of the court that has been declared by state government, their testimony deposition would also be noted, and the provisions in that respect we would discuss later under section 311 and 312 that we would see later. Now, the next provision says that the evidence should be taken in presence of the accused. It says, except as otherwise provided, all evidence taken in the course of trial must be taken in the presence of the accused. Now, State of Maharashtra versus Prafulla B. Desai, AIR 2003, Supreme Court 2053, the Supreme Court observed that this provision contemplates constructive presence. It does not mean always a physical presence of accused, and hence recording of evidence by way of audio video method is also permissible. So, his constructive presence would do, but at the same time this presence must be an effective presence. Effective means that he must have an opportunity to effective opportunity to defend himself by testing the credibility of witnesses through cross examination. That is the idea. It has been provided in Kunal Saha versus Kumar Mukherjee 2011 volume 13 SCC 98, that so long as the accused and or his pleader are present in the court when evidence is recorded by video conferencing, then it would be considered as if it has been recorded in their presence, including through audio video electronic means, designated place to be notified by the state government. Provided, then it says, where the evidence of a woman below the age of 18 years who is alleged to have been subjected to rape or any other sexual offence is to be recorded, the court may take appropriate measures to ensure that such woman is not confronted by the accused, while at the same time ensuring the right of cross-examination of the accused. So, they would be placed in the court in such a manner that if the prosecutrix is below 18 years, that she would not face the accused directly. So, she would be saved from the gaze of the accused directly, while at the same time that the defense lawyer would be able to cross-examine her if it is to be done. I mean, cross-examine on that idea, cross-examination cannot be dispensed with. Cross-examination shall happen of the prosecutrix, but then in such a way that she would be screened from the gaze of the accused. Now, further provision says, record in summons cases and inquiries. Now, in this provision, it says in all summons cases are those cases which are equal to less than 2 years punishable. Then it says in all inquiries under section 164 to 167, they are executive magistrate inquiries, wherein he would be dealing with disputes as to immovable properties, and the idea would be to avoid or to prevent breach of peace thereby. So, that is what is contemplated in 164 to 167, and in all proceedings under section 491. 491 is where somebody furnishes a bond in a court for his presence, and then he does not come present, or some surety furnishes bond for somebody else that he would come present and that bond is forfeited, then in such case it says that as the magistrate shall, as the examination of each witness proceeds, make a memorandum of the substance of the evidence in the language of the court, as we have already seen. Record shall be maintained in the language of the court, provided that if the magistrate is unable to make such memorandum himself, he shall, after recording reasons of his inability, cause such memorandum to be made in writing or from his dictation in open court. If he himself is unable to do that, to make memorandum himself, then he would get it made by upon his dictation in the open court. Such memorandum shall be signed by the magistrate and shall form part of the record. So, this is in these particular cases, that in a summons case, inquiries under these sections and proceedings under these sections, that a memorandum shall be made. We would have some different ideas of recording evidence: memorandum, narrative way of doing it, recording it in narrative way, as in what the witness is speaking, as he speaks, we write it. Memorandum means making a brief, as in summarizing what he said, not writing it exactly word by word. And QA also. QA is also another way of doing it. If some specific point is to be highlighted, then it would be first that a question would be asked from the witness and he would be answering it, and it would be recorded in a verbatim manner. So, that we will see later as they come. So, this is a memorandum has been envisaged here in these three types of cases, specifically 1, 2 and 3. Then here record in warrant cases has been given. Warrant cases both as in on police report or instituted on complaint, that we have already discussed. Section 310, it says in all warrant cases that before a magistrate, the evidence of each witness shall, as his examination proceeds, so it would be made contemporaneously, not afterwards, as in he would speak first and then we would sit and write it. Not in that way. Contemporaneously it would be written, taken down in writing either by magistrate himself or by his dictation in open court. Dictation means that he would be speaking as to what is to be written. So, the writer would be like listening to him and writing whatever he is saying. So, it would be upon his dictation, or where he is unable to do so, as in to write or to dictate, owing to a physical or other incapacity, under his direction and superintendence. Now, this is another way of doing it. Direction and superintendence means that he would be having an eye over the examination, and if some objection etc. are raised by any of the parties upon some question or the way of speaking etc., or what has been written, what has not been written by the writer, then that objection shall be decided by the magistrate. That will be a situation where somebody else is writing, it is not even on the dictation of the magistrate, but then the magistrate is holding the control over the situation. So, it would be under his direction and superintendence by an officer of the court appointed by him in this behalf. Now, here this is connected. It says, where the magistrate causes the evidence to be taken down, he shall record a certificate that the evidence could not be taken down by himself for the reasons therein. Then it says, such evidence shall ordinarily be taken down in the form of a narrative. Narrative means in first person as the witness speaks. That is called a narrative form. But the magistrate may, in his discretion, shall ordinarily be taken down in the form of a narrative. but may in his discretion take down or cause it to be take down any part of such evidence in the form of question and answer. As I said, if the lawyers, advocates want to highlight something, highlight or to be very, very specific about something, then they would resort to this QA method. They would ask a particular question and then the witness has to answer that particular question. Then it says shall be signed by the magistrate. Then let us see how the court of session would record evidence. Section 311. It says in all trials before a court of session, the evidence of each witness shall, as his examination, again contemporaneously proceeds, be taken down in writing either by presiding judge himself or by his dictation, right? So, he would be dictating it or under his direction and superintendence as we discussed just now by an officer of the court appointed by him in his behalf. So, there are three methods of doing it: 1, 2 and 3 in the court of session. Then it says such evidence shall ordinarily be taken down in the form of a narrative again, but it may be taken down in the form of any part of it can be taken down as question and answer. The evidence so taken down shall be then signed by. Now, here if you see, here as in the earlier slide, the magistrate is supposed to record reason that a certificate is to be made by him that he could not take down the evidence himself. No such certificate is required here, because court of session is considered to be a more responsible, a higher court. So, this certificate is not required, dispensed with. Next, language of record of evidence, section 312. Now, it says in every case where evidence is taken down under section 310 or 11, we have seen them: 310 magistrate, 311 magistrate in warrant cases, and 309 magistrate in summons cases, that we already seen. Section 311 court of session, magistrate in summons cases 309. A. If the witness gives evidence in the language of the court, it shall be taken down in that language. So, it is the most ideal situation where the language of the court is Marathi, say for example, and the witness is also giving evidence in Marathi, well and good. But then it says, but if he gives evidence in any other language, then it may, if practicable, be taken down in that language, as in which language he gives the evidence. So, in the language in which he gives evidence, it may be recorded in that language if practicable. I mean, if it is possible to do so in the court, and if it is not practicable to do so, a true translation of the evidence in the language of the court shall be prepared as the examination of the witness proceeds, again signed by etc. Then if he, so that is there. Now, this connects to this. So, if he gives evidence in any other language, it says where under clause B evidence is taken down in a language other than the language of the court. That is, if he gave evidence in any other language and it was found practicable to be taken down in that language, then what would happen? A true translation thereof in the language of the court shall also be prepared as soon as practicable, signed by the magistrate. Because why? Because the record is also to be maintained in the language of the court. Then it says that when under clause B evidence is taken down in English, evidence under clause B means that he gave evidence in any other language, as in suppose the language of the court was Marathi and somebody gave evidence in English and it was found to be practicable to be recorded in English, then and it was recorded in English, then it may not then be translated into Marathi also what? If it is not required by any of the parties. So, if no party, as in none of them require its translation in Marathi, now this concession is only with evidence is recorded in English. So, if none of the parties require its translation in Marathi, say that is the language of the court, then the court may dispense with such translation to be done in Marathi, which may be the official language of the court in a given case. Now, further, procedure in regard to such evidence when completed, section 313, it says when the evidence of each witness taken under section 310(11), again magistrate, court, warrant case, court of session is completed, it shall be read over to him in presence of accused, of course to the accused or to his advocate, and shall if necessary be corrected. Now, this relates to this. It says that if the witness denies the correctness, then the magistrate or judge, as the case may be, instead of correcting the evidence, make a memorandum thereon of the objection made to it by the witness and shall add such remark as he thinks fit. Then it says, so if necessary be corrected, or instead of correcting it, the memorandum of objection etc. shall be made. Then it says, if the record of the evidence is in language different from that in which it has been given, and the witness does not understand that language, the record shall be interpreted to him in the language in which it was given or in a language in which he understands. Now, let us quickly come to another provision, that is section 314, which says that whenever any evidence is given in a language not understood by the accused. Now, witness is giving evidence in a language which is not understood by the accused, and he is present in court in person, it shall be interpreted to him in open court in a language understood by him, so that he should know what is going on against him in the court. And if he appears by an advocate and the evidence is given in a language other than the language of the court and not understood by the advocate, it shall be interpreted to such advocate in that language. So, the idea here is, if the advocate is present, he must be knowing the language of the court, but if it is not even in the language of the court, in some other language, and it is not understood by the advocate, then it shall be interpreted to such advocate also. Then it says, when documents are put for purpose of formal proof, it shall be the discretion of the court to interpret as much thereof as appears necessary. Then remarks respecting demeanor of witnesses, section 315. This section says, when a presiding judge or magistrate has recorded the evidence of a witness, he shall also record such remarks, if any, as he thinks material respecting the demeanor, because demeanor is a very important criteria to know about somebody's credibility while he is speaking. But then, in the garb of recording demeanor, the court should not write down or record its remarks about the substance of what the witness has said. So, say for example, the court may write that his manner of speech was such as not to inspire confidence, that is permissible, but the court should not write that the witness not spoken the truth. Such remarks would not fall under this section and they should not be recorded. Another idea around this section is that, now you see, the trial court would be doing that, because in higher courts generally the witnesses may not be examined. In a general way, witnesses are not examined in higher court. So, that privilege of looking at the witnesses while he is speaking, looking in his eyes, looking at his demeanor would not be available with the higher court, and so it is said that the higher court should be slow in interfering with, though that can be done, I mean in appellate jurisdiction that can be done, but then they must be slow in interfering with the finding of fact by the trial court. Why? Because the trial court had the privilege of noting the demeanor of witnesses here, that they can record it also. Then it says, record of examination of accused, section 316. Whenever the accused is examined, this examination is not that he is coming as a witness. He is not coming as a witness. If he comes as a witness, under section 353, his testimony shall be recorded under section 309, 10 and 11 BNSS. Here, the accused is not coming as a witness. Here, he is examined under section 351. Under section 351, not as I said as a witness, but with a view to know about his side of the story. So, he would not be administered oath, he would not be cross-examined by the other party, and it would be between the court and the accused. So, about such examination it is said that when such examination is conducted of the accused, then every question put to him by the court and every answer given by him shall be recorded in full by the presiding judge magistrate himself, etc. Record shall, if practicable, be in language in which the accused is examined, or if not practicable, in the language of the court. Record shall be shown or read to the accused. It shall thereafter be signed by the accused and by the magistrate, and that is the provision. Interpreter to be bound to interpret truthfully. Section 317, it says, when the services of an interpreter are required by any criminal code, that we have already seen in so many sections before, then he shall be bound to state the true interpretation of such evidence or statement. Otherwise, perjury may follow against him. Record in High Court, section 318, it says, High Court, the proceedings would take place as it deems fit. It says, it by general rule prescribe the manner in which the evidence of witnesses. So, High Court would be devising its own method. Then it says, when attendance of witness may be dispensed with and commission issued. Now, here the general idea is that the witnesses must be examined in the court. Now, Supreme Court in Dharmanand Pant versus State of UP, AIR 1957, Supreme Court 594, observed that in criminal cases, ordinarily witnesses should not be examined on commissions except in extreme cases of delay, etc., or inconvenience, and important witnesses, especially that they should be examined in court. Commission may be issued for formal witnesses, as in witnesses of search, seizure, etc. Or suppose a police officer lifted fingerprints from the scene of crime, then such police officer may be examined in the court that he lifted fingerprints from that particular place. He would be a formal witness. He may be examined in this way. Now, commission to whom to be issued? It says, if the witness is within the territory to which this Sanhita extends, the commission shall be directed to the CJM, within whose local jurisdiction the witness is to be found. And if, so say for example, a formal police witness has been transferred to some other place. So, instead of calling him to this place where the trial is going on, a commission would be issued to the CJM of that place, within whose local jurisdiction he might still be working somewhere. Then it says, if the witness is in India, but in a state or an area where Sanhita does not extend. Now, the place would be in India, but where the Sanhita does not extend means section 1(2) of BNSS says that the BNSS would not be applying to the state of Nagaland and tribal areas. So, if the person is here somewhere, then the commission shall be directed to such court or such officer as the central government by notification specify. And if the witness is outside India, then as the arrangements made by the central government, etc., the commission shall be issued. Execution of commission. Upon receipt of the commission, the officer, etc., getting that commission shall summon the witness before him or proceed to the place where the witness is and shall take down his evidence in the same manner as in trial of warrant cases under Sanhita that we have just seen before, as in trials of warrant case. Parties may examine witnesses. Section 322. Parties to any proceedings under this Sanhita in which a commission is issued may respectively forward any interrogatories in writing with the commission. So, they would be sending questions that should be asked to that witness, and then those questions would be put before the witness. Then it says any such party may appear before such magistrate court officer by an advocate, or if not in custody, in person, and may examine, cross-examine and re-examine the said witness. So, the party may go there and cross-examine that witness. Now, next provision is return of commission. It says section 323, after the commission issued under has been duly executed, it shall return with a report to the court sending it. Return of commission. Now, this is 324 is adjournment of proceedings, and it says in every case where commission is issued under section 319 as we have seen earlier, the inquiry, trial, etc. may be adjourned for a specified time, as in to get the report back from the commission. Then it says execution of foreign commission. It says provision of section 321, 322, 323 so far as they may relate to the commission issued by court, that they would apply to that also. Deposition of medical witnesses. Now, that the deposition of a civil surgeon or other medical witnesses taken and attested by a magistrate in the presence of accused or taken on commission under this chapter may be given in evidence in inquiry, trial, etc., although the deponent is not called as a witness. Not called as a witness as in there has been no opportunity to cross-examine him. It is simply their deposition, that they state something, that they gave their opinion on something. Then the law says that the court may, if it thinks fit, and shall, on the application of the prosecution or accused, summon and examine any such deponent as to the subject matter of his deposition which has been given here. So, the idea here is that if somebody is a medical witness, his deposition as in statement, opinion, etc., the idea is that it is without any cross-examination that would be considered as evidence, without any cross-examination. Something is, the basic rule is that a statement in normal circumstances generally would not be considered as evidence, would not turn into evidence as such in legal sense unless he is cross-examined. Now, here we are relaxing that idea in favor of medical witnesses, but then at the same time we are holding that if the parties wish to cross-examine them, they must be called in the court. Reports of certain government scientific experts, reports. It says that if a document is a report under the hand of a government scientific expert, it may be used as evidence in proceedings under Sanhita. And again, if it thinks fit, summon and examine any such expert as we have just seen. Then it says when any such expert is summoned by a court and he is unable to attend personally, he may depute any responsible officer working with him to attend the court, of course, unless the court has expressly directed him to appear personally. And then it says this section shall apply to the following government scientific experts. So, these particular experts have been mentioned here. To them this section would be applying. So, basically, I mean, as a ground position they need not to come to the court, but if they are required then they would have to come to the court. No formal proof of certain documents. It says section 330, it says where any document is filed before any court by the prosecution or accused, the particulars of every such document shall be included in a list, and PP or the defense lawyer, as the case may be, shall be called upon to admit or deny the genuineness of each such document soon after supply of such documents, and in no case later than 30 days after such supply. Genuineness basically is related to the execution of a document. So, execution may be like handwriting, if it is handwritten, signature, etc. So, if handwriting, signature, etc. they are to be admitted or denied. So, it says where the genuineness of any document is not disputed, such document may be read in evidence in such proceedings without proof of the signature of the person by whom it is purported to sign. So, that is the idea, that if some document's genuineness is admitted, then it need not to be proved. Of course, if it is not admitted, then the other party has to prove that it is a genuine document. Evidence of formal character, again as I said, formal witnesses, search, seizure or something, as we discussed, a police officer lifted fingerprints from somewhere, but not, I mean, if somebody is an eyewitness, then this provision shall not apply. So, it says the evidence of any person whose evidence is of formal character. So, that is the idea, may be given by affidavit. So, his evidence may be given by an affidavit. So, he would say in affidavit that yes, I lifted the fingerprints from so and so place at so and so date, etc., or that I attended the search seizure so and so, and may subject to all just be read in advance. So, such affidavit, so you see, affidavits are not evidence. Section 1(2) Bharatiya Sakshya Adhiniyam says that affidavits are, I mean, generally speaking, affidavits are, they are not considered to be evidence. Why? Because they are just sworn statements. So, what is the meaning? The meaning is that somebody here is saying that I swear that this is true. There are two parts. One, that this is true on my personal knowledge, that I know that it is true, and the second part happens to be that something is true as I have reasons to believe that it is true. So, that is called an affidavit. The idea is that it does not become evidence. Why? Because it has not yet been tested by cross examination, not yet been cross examined. And as I said, somebody's statement generally would not be called as evidence in legal sense unless such person is cross examined by the other party. So, affidavits are not subject to cross examination, as in if they are filed in a court, the deponent is absent there. So, who would be cross examined? So, that idea. Now, if the evidence is of formal character, then it can be given on affidavit. It may be read in evidence, and then it says the court may, if it thinks fit, and shall on the application of prosecution or accused, may examine any such. So, if any party wants to call such deponent, he would be called in the court and cross examined, of course. Authorities before whom affidavit may be sworn, section 333, it says it may be sworn before judge, judicial, executive magistrate, or any commissioner of oath appointed by a high court or court of session, or any notary appointed under Notaries Act. So, it should be a judge, a judicial or executive magistrate, session judge, high court judge, supreme court judge, judicial magistrate, executive magistrate, commissioner of oath appointed by high court or court of session, or a notary appointed under Notaries Act. Then it says, affidavit shall be confined to, shall state separately such facts as the deponent is able to prove from his knowledge and other facts which he has reasonable ground to believe, as we just discussed here. This is where perjury may be brought against him. So, if this part is found false, then perjury may follow against him. That is the significance of this part particularly. Then it says, and in the later case, the deponent shall clearly state the ground. So, if this is the case, he should state the grounds of his holding that belief clearly. Then it says, record of evidence in absence of accused. Now, this is an exception, as in we have seen that record of evidence should be made in presence of accused, maybe direct presence of accused, constructive presence of accused. Actually, it is an exception to that general rule. Here, the accused is not contemplated to be convicted in absentia. It is rather to use such deposition against him in certain circumstances. If suppose witness dies, etc., or is otherwise incapable of giving evidence, etc., when he subsequently appears to face the trial. So, it is just that we are recording the evidence, not that we are trying him and convicting him or punishing him. Prosecution has to show what steps have been taken to produce the witnesses before this section is resorted to. And if we read it, it says, if it is proved that the accused person has absconded, then it says that let us examine the witnesses and keep their statements. I would say statement because they are not subjected to cross examination because the accused has not been present in the court. So, they would be statements, but let us keep those statements in the court till the accused finally appears in the court, that we take their depositions of witnesses, not evidence, as I said, that there is nobody to cross examine them. We take their depositions, record them and use them given in evidence against him on the inquiry or trial for the offence. So, whenever he appears, that their deposition may be read in evidence now, evidence if the deponent is dead or incapable of giving evidence or cannot be found or his presence cannot be procured without an amount of delay, expenses or inconvenience, etc. So, if that happens, then in that case their deposition would be read as evidence against the person, but then the prosecutor here, the prosecution side has to prove that these things happen to the deponent, then only that it can be, this provision can be used. Then it says evidence of public servants, experts, police officers in certain cases. The idea is that if somebody is transferred, retired, died or otherwise cannot be found incapable of giving deposition or is likely to cause delay in holding, the court through his successor officer. So, whosoever is holding the office currently would be called in the court and that he shall be giving deposition about such document or report. Of course, if it is about some document or a report. Then chapter 27, it is about the procedure in case of accused being person of unsound mind. As I said, we are not contemplating a situation where he was unsound mind at the time of crime, because that would be something which would result in his acquittal. We are contemplating a scenario where he is of unsound mind at the time of trial. The idea is that till he is unsound and is facing a trial and is unsound, he would not be able to look after his interests. So, a fair trial is not possible in that case. So, here we see that he shall be examined through such surgeon, medical officer, etc., and then he would be sent to government hospital. If civil surgeon finds him to be so, he would further be sent to clinical psychologist and then he would be deciding about his mental status. Then it says, if the magistrate is informed that he is currently a person of sound mind, Then he would further determine whether such unsoundness of mind is rendering him incapable of entering defense. You know, he is of unsound mind, and that unsoundness of mind is preventing him from raising his defense in a proper manner. Then, after that, he shall examine the record of evidence produced by the prosecution and hear the advocate from both sides, advocate and the public prosecutor. And if he thinks that there is no prima facie case, he shall discharge the accused. But if he finds that there is a prima facie case, he shall postpone the trial. Now, moving further, it says procedure in case of persons of unsound mind tried before the court. If it says it at the trial of the court, now it is so earlier we were contemplating wherein in an inquiry that you see here, it says where in an inquiry that a person is facing that he is of unsound mind. And here we are contemplating a situation that if a person is facing a trial and then in that trial he is found to be of unsound mind, the procedure is similar as we have seen before. Now, section 369 says, whenever a person is found under section 367 as in inquiry or under section 368 as in trial to be incapable of entering defense by reason of unsoundness of mind or intellectual disability. So, if he is found to be a person incapable of defending himself, the magistrate or court, as the case may be, release such person on bail, provided that the accused is suffering from unsound of mind or intellectual disability which does not mandate inpatient treatment, and a friend or relative undertakes to obtain regular outpatient psychiatric treatment for him. That means that he must not be a person who require an inpatient treatment, mandate inpatient treatment, and so he can be treated outside as in while being in his own place or at somebody else's relative's place, etc., and somebody is willing to take him. In that case, he would be granted bail. If the case is one in which in the opinion of magistrate he may be, bail cannot be granted. So, bail may not be granted if he requires an inpatient treatment or if nobody is willing to take him, nobody is giving that undertaking. In that case, the court shall order that the accused be kept in such a place where regular psychiatric treatment can be provided. Resumption of trial. It says whenever an inquiry trial is postponed under section 367 as we have seen, then that is the situation where he is found unsound and the material is found in prosecution side as in it holds substance, the trial shall be postponed and it may at any time after the person concerned has ceased to be unsound mind resumed. Then accused appears to have been of sound mind. It says, now this is a case where the person was unsound at the time when he committed crime. So, such person shall be proceeded ordinarily as in a normal case. Now not unsound mind. So, he will be tried ordinarily. This case is where the person has been of unsound mind at the time of crime and now that he was of sound mind, tried as we have said here. Now, if he is tried and acquitted because of course he was found unsound at the time of crime, so he would be acquitted, then this section says that the court shall reach upon a finding specifically whether he committed that act or not. That has to be a specific finding, and it says if the person committed that act, he was acquitted because he was unsound, but he committed that act. So, he killed somebody, but because he was unsound, so he was acquitted. Now, if that is the case, the court says that he would be kept in such a place and the manner as the magistrate thinks fit, or order such person to be delivered to any relative or friend of such person, etc., so as to keep him in safe hands and to ensure the security in the society. Thank you.
Hi, my name is Gillette Sam, and I teach sociology at IIT Kanpur. Today I'm going to tell you about the different characteristics of the movement of things around the world that are associated with globalization. We refer to these kind of movements as global flows. Now, the concept of global flows is quite important, and it's important for us to understand the different ways in which these flows might occur. Now, typically, when people talk about the movement of things from one place to another in the context of globalization, they're under the misconception that things tend to flow from abroad into the place where they are living. In a very sort of stereotypical manner, there is this idea that with globalization, much of the movement that occurs is from Western countries into non-Western countries. Now, as sociologists, we know that actually global flows are multidirectional. So, which means that as much as there is a movement of flows from Western countries into non-Western countries, there is an equal amount of movement of flows from one non-Western country to another non-Western country, and in fact, a movement of flows from non-Western countries into Western countries as well. Let's take the example of food, for instance. You may be aware of a type of food which originated actually in China and then goes on to Japan called ramen. For instance, the popular brand Top Ramen that is consumed in India is an example of ramen. Now, ramen, initially the movement is from China, which is a non-Western country, to Japan, which is another non-Western country. From Japan, this very popular food item travels to Western countries, such as the US, and also more recently to countries in Europe. So there you have a movement from a non-Western country to a Western country. And in fact, now we have very specific types of ramen being consumed in metropolitan centers in India as well. So there's another movement from a Western country to a non-Western country, which is India. So global flows in that sense are multidirectional. A second aspect of global flows is that they could be interconnected. An easy way to think about this would be if you have relatives who are traveling from the US or the UK or Australia, very often you'll see that people request them to carry electronic items with them. They say, oh, can you please get me a laptop, or can you please get me the specific camera lens that I'm looking for. So here you see that the movement of people, which is a person moving from one country to another country, is connected to the movement of technological items as well. So global flows in that sense are interconnected with each other. A third characteristic of global flows is that we could see that they happen in reverse. In fact, they are called reverse global flows. An example of a reverse global flow would be a style of music that you may be very well acquainted with, which is Bhangra. Now, Bhangra music is something that originated, as we know, in the state of Punjab. Now, as you know, Punjab is also a state which has seen a lot of out migration, not only to other parts of India, but also to other parts of the world. So as people migrated to other parts of the world, they took their music with them. So when people migrated from Punjab to the UK, for instance, they hung on to the music that they were familiar with. So Bhangra moved from little villages in Punjab to the major cities where people from Punjab settled to in the UK. While in the UK, uh, over subsequent generations, this music was transformed. It was not only performed in its original version, but it was also performed with the addition of many different types of beats, which are more familiar to people in the UK. At one point in time, you see that this modified form of Bhangra comes back to India. We're talking about the 1990s, the 2000s. So here you see that that a form of music that originated in India moves out of India to the UK. It is modified a little and then comes back to become extremely popular in India again. So in some ways, this form of music is returning to where it started out, but in a slightly changed manner. We call this kind of movement as a reverse flow. Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I am going to tell you about an important debate that is occurring around the concept of globalization. Now, within the study of globalization, there are two sets of people. The first set of people argue that globalization is very real. It's something that is happening around us all the time, and in fact, it's something that is gaining strength over time. The second set of people, and the first set of people are called the globalists. The second set of people are not so convinced that globalization is something real, and they are referred to as skeptics. Now, the skeptics argue that unlike what the globalists would have us believe, that there are things and ideas and people that are traveling across the world, across multiple borders, and that we live in an interconnected world, actually, there are many parts of the world and many types of people who are completely left out of these kind of global flows. So they would give you the example of typically indigenous communities who live across the world. And they would argue that if you look at the lives of indigenous communities, particularly tribes that are quite isolated in terms of their physical location, their lives continue without their participating in any kind of global flows. To this, the globalists would respond that even though people may live in isolated and remote locations and they may not be directly involved in global flows, their lives today are still being influenced by events that are happening at a global scale. You can take the example of climate change. So, for instance, if there is an indigenous community that has no contact with anyone else in the world apart from themselves, but they live in an area which is experiencing an increase in sea levels and increase in the temperature. All of this may be attributed to people in neighboring countries, or actually rather events that are happening across the globe. So in that sense, even though you may not be directly participating in global flows, your everyday life is affected by what is happening around the world. Another argument that the skeptics make is in regard to what happens with the nation states. Now, initially, when discussions about globalization started, and we are talking about the 1990s, the expectation was that the nation state as an entity is going to wither away. It's going to cease to be important. Now, skeptics could point out to the world today and say, well, nation states are still important. We still live our lives based on which nation we were born in or which nation we have citizenship in. Their rules and regulations are still important for us. To which globalists would argue that this expectation that the nation state will cease to be important, that itself is a fallacy. Rather than facing a situation that the nation state becomes less important over time, we actually may be headed towards a situation where, in addition to the nation state, there are other laws which become important to our lives, and they shape our lives on an everyday basis.